Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put those questions in the comments. I will answer as long as they're immigration related. I have a great topic for you today as well. I'm going to be talking about going from the 2-year green card to the 10-year green card. What does that look like? And what, especially in the case where you cannot apply for the 10-year green card with your spouse, how can you do it on your own? Because yes, there is a way to do this on your own. Now, let me explain what the 2-year green card is, because if you're on your way to get a green card, you'll want to know whether you're going to be getting the 2-year green card or you're going to be getting a 10-year green card. Now, the 2-year green card is usually given to an individual who is applying through their U.S. citizen or legal permanent resident spouse, and at the time that they're approved, they've been married to that spouse for less than 2 years. If that is the case, you'll get a 2-year green card. And the 2-year green card is like a probationary period. So they want to see you go ahead and submit documents to remove the conditions on the 2-year green card. I sometimes refer to this as renewing the 2-year, just because it is a simplistic way to describe the process. But it's really called removal of conditions, and there's a special form for the to remove the conditions on your 2-year green card to get the 10-year green card. Now, when you submit this application, it is due within 90 days before the expiration of your 2-year green card, and you are required to apply with your spouse. And jointly apply. That means that both of you will sign the same form and jointly submit your evidence to show that after you receive the 2-year green card, you continue to have a bona fide marriage. That means a real marriage, and it proves to the immigration service that this was not a fake marriage, that you do indeed have every intention to spend your lives together. It is very important to be on time with applying for this, because if you apply after the deadline, the immigration service can, and they have, denied applications, and they've sent it straight to immigration court for removal proceedings. It's very important to give yourself, make sure that you don't get into those kind of complicated situations, because if you don't timely apply and it gets denied, the next thing is that they will send it to immigration court so that they can take away your permanent residence. So you want to make sure you're on top of it. And if you are with your spouse, you have to make sure you jointly file. And here's another tip. You cannot apply for renewal of the 2-year green card like a regular green card. There's a special form to remove the conditions on your 2-year where you jointly have to file. It's called the I-751. That's the form that you would use. You will not be using the I-90 that is used by individuals who have their 10-year and they're just trying to get a renewed 10-year green card. So those are different processes. Now, what if you broke up with your spouse? What if you're separated? What if you don't trust your spouse anymore to jointly file with them? Can you file for this on your own? And the answer is yes. You have to file for this, though, showing and submitting a formal request for the waiver based on divorce and bona fide marriage, based on mistreatment or abuse and bona fide marriage, abuse by that U.S. citizen spouse or resident spouse, or based on your extreme hardship. This is the process. This is not just a fill in the blanks type of situation when we talk about the waiver. It is a situation where you'll have to submit evidence and a formal request for the waiver. So very important that you understand that, because if you don't apply for this waiver, what will happen is you could be denied, you will be denied, and then sent to immigration court for removal proceedings. That just gets more expensive, more complicated, and stressful, of course. So this can also, you can also apply for this waiver after you've jointly applied with your spouse. This does happen too, where you jointly file with the spouse and then things start to fall apart while you're with the spouse. And these waivers can be applied for at any time. If you divorce your spouse before your 2-year green card expires, the waiver is still available at that point as well. So there is no deadline for waivers. You can apply for a waiver at any point before or after the due date for the removal of conditions on the 2-year to the 10-year. So that is my information on the 2-year to the 10-year, what it all entails, and also ways to apply for it if you cannot apply jointly with your spouse. Now, with the divorce, you must have a final divorce decree, but it's okay to request the waiver while you're waiting for the divorce to be finalized. You just also have to make sure you show sufficient evidence that your marriage was real. Also, with mistreatment, if you've been verbally abused, mentally abused, emotionally abused, that also counts here to get a waiver based on abuse, especially in situations where you have not divorced, you're separated, or you don't trust your spouse to apply with them. And then extreme hardship is going to come down to all the different hardships that can come out of it, that can happen if you lose your status and you have to return to your home country. If you are in a situation like this, I encourage you to go ahead, call and schedule your appointment so we can get started on your process, get a waiver in if necessary, or you and your spouse can work with me to ensure that you get through this process smoothly and that you do everything correctly to avoid complications. My number is all over my videos on the page, or you can call 561-405-4889. You can also go to the link in the profile on YouTube or on TikTok, and it will take you to the website where you can get in touch, schedule your appointment, or call. So go ahead. I'm looking forward to hearing from you. Now I'm going to go ahead and answer questions. So let's see the questions that have come in. Hi there, Shalina. Can I still apply for the marriage visa after the 180 days are up? So, Shalina, that's going to come down to your particular circumstances. I would need to know what your situation is. In some cases, and I think you're talking about 180 days that you have to be here in the United States legally. It's going to come down to the status of your spouse. How did you get here? What is your current situation? In order to determine whether you can do that. It may be possible. Shalina, go ahead, call, schedule an appointment. It really comes down to what's going on with you and your spouse right now to answer that question. Now, remember that the information I'm giving you is general information. It's not personal legal advice. And so you want to make sure that you do yourself justice by making that investment, calling and scheduling an appointment if you really would like to make sure you get the representation you need, get the legal advice you need. It's been 1 year and 4 months since the I-130 has been submitted. No updates, only showing received. So you're not alone, honey bun. Make sure you check on your case. And you can contact them if you have any questions. I'm not your attorney, so I wouldn't be able to tell you what's going on, but I can tell you that is not strange. It is taking over a year to get these approvals on the I-130. How do you schedule an DS-260 appointment in Liberia? He was told he needs more evidence. So the DS-260 is that application that for the immigrant visa, that's where the spouse or the family member is coming to the United States through consular processing, through the embassy. They're going to get an immigrant visa to come. Now, if they're telling you that he needs more evidence, you have to get through that portion. What usually happens is so I notice here you have to reschedule the DS-260. Talk, the embassies are different in different locations. Their policies are different. I'm not your attorney. I haven't reviewed your case. And so I can't tell you specifically what to do in that case. I only do that for my clients when their case is at a particular embassy. But I would need to know what's going on in the case here, because you have the appointment. Is this the interview? And if he already attended the interview, what kinds of evidence does he need? So the answer here is going to be dependent on the embassy's policies, and it's going to be dependent on what types of evidence is required. So you'll need to get in touch directly with that, with the embassy. Good afternoon. How long would it take you if you're not married as yet, but your spouse is in the US? So it's the average time, I would say, is 18 to 24 months. That's an estimate based on my experience as an attorney, but it could be different. It just depends on your circumstances. So make sure you schedule that consultation. So, Abaco, you'll have to check with the state requirements for that. Why I started abusing, I'm green card holder, I lost or never received the file and waiting on I-90. Can I file? So, Mohammed, that is going to definitely be a consultation here, because I would not be able to confirm whether you can file anything. I don't know what your situation is. I notice here that you said that there was some abuse, and I would like to know, do you have the 2-year green card already? Do you have the 10-year? So these, I would definitely have follow-up questions here. But I just would like to caution you here that if you're going from the 2-year green card to the 10-year green card, you wouldn't be using an I-90 form. So that's first thing. Make sure you get legal advice and representation, because you don't want to be gambling. When not sure, get legal advice. Because it's the I-751 that you would be using in this case, along with the evidence. So the form is just one part of it, but you have to also look at evidence. So I have some more questions regarding what you can file for, and how the abuse is relevant to your situation. How long would it take for you to get So, Shakira, it's not down to a science, because you haven't filed your application. The average time right now on a whole is 18 to 24 months. So DJ Chino, so I see here, so if you got married, how much time and it's going to be about 18 to 24 months for the marriage base. But it also depends on whether do you need a waiver? Do you need additional requirements? And so a consultation is going to be very important there. The service center for I-130 is California. They recently updated their time to October 2019 from February. Okay, yeah, so that's a good place to find the processing times. Why I started abusing, I'm a green card holder. So I answered that already. So just Tony, what's your contact information? How much is a consultation? So the consultation is $150 for up to an hour. And the contact information, if you go to the link in the profile, you will see everything that you need. It is well worth your time and money because you get personal legal advice and baby boo. That's why it's not a free consultation, because you do get value, you get personalized legal advice in that time, and then you do get the option to be represented by an attorney, should you qualify. You're welcome, Shakira. So, Tawa, what state are you working in? I am a US immigration attorney, so I represent my clients in all 50 states and the globe. If you are anywhere in the US, I'm not limited by borders or state lines. I can represent you as long as you have a US immigration issue. The reason for that is because it is a national federal practice. It's my first green card. I'm on IR1 visa, never received. That's why I filed the I-90. So, Mohammed, get that consultation because it sounds like if you never receive the permanent residence, do you have a 2-year? If you have a 2-year, it's not definitely. The I-90 you can apply to replace, but it's not going to give you a 10-year. If it's time for you to apply for a 10-year from a 2-year, you're going to have to go through the removal of conditions process. So this is all the more indication, Mohammed, that you need legal representation because you may be on the wrong track here. So make sure that you schedule a consultation and, protect yourself. Can I make an appointment for today? Baby boo, the scheduling coordinators can speak with you and they're in charge of my schedule. It's highly unlikely that you can schedule your appointment today and confirm your appointment. However, it's highly unlikely we'll be able to do a consultation today. But the sooner the better. Get ahead. Call, schedule that appointment, and you can get in sooner rather than later to be able to discuss your matter. Is the processing time on the website usually accurate? It jumped from February 2019 to October 2019. So they may have some backlogs in even updating those processing times. But what it means when they jump from February to October is that they are moving ahead. So they moved ahead and they updated the website. It's not updated on a daily basis, and so it's very possible that they just are catching up on their updates. My I-751 was approved. I won't get green card. I'm waiting on my oath. Can I start filing for my parents now? Once you're not a citizen until you actually take the oath. So once you're sworn in as a citizen, then you can file, but you are not a US citizen. So don't put anything anywhere on any documents that you are a US citizen. You're only a US citizen after you're sworn in. So just keep that in mind. And just as a side note, it's very dangerous when you do have the misconception that you're already a US citizen when you're not. And so that's where I want to caution individuals here that you should not, if you're not a citizen, if you don't have any valid evidence that you've been sworn in as a US citizen, if you have not been sworn in as a United States citizen, you should not be putting that you're a US citizen on any documents, claiming this to any individuals or any organizations, especially the immigration agencies, or putting this on jobs or I-9 forms. The reason I'm cautioning you about this is because it causes devastating consequences when you have claimed you falsely claimed citizenship. It can lead to deportation. You would be stripped of your permanent residence and you'd be permanently barred from getting citizenship. So very important that you only claim citizenship when you absolutely know that you're a citizen. And usually that's when you're sworn in and you get your certificate of naturalization. I applied for my spouse in 2018. She's in Afghanistan, and I'm a green card holder. So, and I hope that she's safe. And I know that there is a lot of turmoil going on, and there are a lot of individuals trying to come to the United States. Now, Tawabi, if you need assistance, you can always call and schedule a consultation so we can talk about your case. But if it's currently being processed, if your I-130 hasn't been approved, then it's still in process, or we would have to figure out the next steps depending on where she is, or how she can be able to get here to the United States. So Amelie, go ahead. You can call the number or you can click on the profile. So click on the profile and click on the link in the profile, and it will give you all the options to be able to schedule a consultation. Urana, hi there. Nice to see you. All right. So keep putting those questions in the comments and I will answer your questions. I still have some time to answer those questions. Now, I just want to make it clear for all of you that if you would like to schedule a consultation, you can do that by going to the link in the profile. It's going to lead you to a website where you can schedule your own appointment, where you can also go directly to the website, and you'll see the phone number, contact form, and also an online chat. You can use any one of those options to speak to a scheduling coordinator. Scheduling coordinators are available up until 10:30 p.m. Eastern time. So we do go late into the night, Monday to Friday. So when you apply for a T visa, when do you get a work permit? So Urana, the T visa, for those of you who are listening, the T visa is for victims of trafficking. And now keep in mind, victims of trafficking, it comes in different forms. It can come in the form of relatives taking you here to the United States and then forcing you to work. It could be an acquaintance or a boyfriend taking you here, forcing you to do things against your will. It could be you working for an employer and them mistreating you, not paying you lower than what's legally required to pay you. And then threatening you if you are trying to leave or you feel as if you're not free to leave. So these are examples of trafficking. Now, the processing times for T visas right now is anywhere from 6 months to a year. And the work permit only comes for the T visa after the T visa is approved. And the processing times for approvals right now is anywhere from 6 months to a year. Can a J1 apply for an extension? So now some J1s you're able to apply for an extension and some don't allow for the extension. So it's going to depend on what type of J1 program you're in and under what category. Do I have to be in the US to file for my husband? So Amelie, you will have to show domicile, that you do have domicile, you maintain domicile. You don't have to necessarily be physically present at the time you're filing your petition, but when your spouse is coming to the United States, you have to show that you have domicile in the United States. That means that you're connected to the US, you have a residence here in the United States, and your spouse will be coming to settle here in the United States with you. Stacy Pang, thanks for the share, and thanks so much everyone for sharing the live, for your love. I appreciate that greatly. Hi there, Kimberly. It's nice to see you. All right, so that's going to be it for me today, but I'm not done yet. I'm heading on over to Instagram where I'm going to continue taking questions there. So you can hop on over to Instagram. If you go to the profile page on TikTok, you will see a button. Click on that button and it's going to take you directly to the to Instagram. Also, I'm the immigration attorney on Instagram. So you can simply go to Instagram, type in the immigration attorney, all one word, and you'll be able to find me there. I'm going live there to continue the conversation, to continue taking questions. So if you didn't get to ask any questions here, or you think of a question after this live, you have another opportunity to join me and continue asking questions. I will be back tomorrow at 4 p.m. Eastern time. So if we don't talk today, you can join me tomorrow and you can continue to ask your questions. Remember, the information I've given you today is not legal advice, it's general information. That's why it's essential to schedule a personalized consultation so that you get the information you need to understand your process, to gain options and representation through your process. I will see you tomorrow at 4 p.m. Eastern Time, or I hope to speak with you in a consultation. Have a good one, guys. Bye-bye.